like to move the Abortion Northern Ireland Regulations 2021. These regulations will provide the Secretary of State with the power to direct a Northern Ireland Minister, a Northern Ireland Department, the Health and Social Care Board of the Public Health Agency to take action necessary to implement all of the recommendations in paragraphs 85 and 86 of the 2018 United Nations Committee on the Elimination of Discrimination Against Women, known as CBR report. We recognise this is an unprecedented step, but such is the nature of the statutory duties on the Secretary of State for Northern Ireland that we have to act. And while the regulations themselves are short, they are necessary to ensure that abortion services are available as a healthcare service in Northern Ireland, which will provide safe and local access for women and girls. We have made the most appropriate step in terms of the scope of any direction being limited to only what is needed to ensure that the CBR recommendations are implemented. This power, if exercised by the Secretary of State for Northern Ireland, can only be used for those purposes and will go no further. My Lords, let me remind the House of the background to this. The House will recall that in 2019, during an ongoing absence of devolved government in Northern Ireland, Parliament decided it was time to step in on this matter on the basis of human rights. These statutory duties did not fall away with the restoration of devolved government. We have always sought to deliver in a way that respects the devolution settlement by putting in place the legal framework, but recognising that healthcare is devolved and therefore service provision should be delivered and overseen locally by the Department of Health and relevant health bodies with the relevant legal powers, policy and operational expertise to do so. Noble Lords will also recall the previous debates that we have had on the 2020 regulations and the strongly held views across the Chamber on a range of finely balanced policy issues. This debate today is not about reopening that. This is about ensuring that the duties under Section 9 of the NIEF Act can be implemented in full at the earliest opportunity. It is our firm view that the regulations we made in 2020 established a new legislative framework that is operationally sound, works best for Northern Ireland, and delivers on the government's statutory duty. And that is why we do not intend on amending the regulations. So, my Lords, why are we here today? We are here today to do everything we can to demonstrate how committed that we are to fulfilling the government's statutory obligations and to ensure that women and girls in Northern Ireland have access to high-quality abortion and post-abortion care, consistent with the conditions set out in the 2020 regulations. As I said, I recognise the emotive nature of these issues. But what is the issue at hand? As many Noble Lords will be aware, over a year after the 2020 regulations came into force, women and girls in Northern Ireland are still unable to access high-quality abortion and post-abortion care in Northern Ireland, and the commissioning of full abortion services consistent with the conditions set out in the 2020 regulations. My Lords, it has still not happened. In 2019, 1,014 abortions were provided in England and Wales for women from Northern Ireland, and women and girls are still having to travel to access these services. It has always been our expectation and preference that the Department of Health drive forward the commissioning of abortion services and to ensure that these services become embedded into the health and social care system in Northern Ireland as an accepted and recognised healthcare service. While some abortion services have been provided since April 2020, and over 1,100 abortions have been provided in Northern Ireland, I am disappointed that services have not been formally commissioned, supported or funded by the Northern Ireland Department of Health, and there has been no guidance issued or official support measures put in place. I hope that Noble Lords will agree that at the very heart of this matter are the women and girls and their health who have been and continue to be denied the same reproductive rights as women in the rest of the UK. Women and girls are entitled to safe, local healthcare. Indeed, during the pandemic, this is even more crucial. We understand that managing the COVID-19 response has been an immense challenge and has placed the health and social care system in Northern Ireland under considerable pressure. However, The fact of the matter is, the law changed over a year ago now. This is not a new issue. It is a surprise to the Executive, following the Northern Ireland Executive Formation Act receiving royal assent and the Section 9 duties coming into effect. We engaged with all of the Northern Ireland parties on this matter, and we continue to engage, being clear that Parliament had stepped in, and we will be delivering on those legal duties accordingly. So we are disappointed with the continuing failure of the Department and Health and the Northern Ireland Executive to commission abortion services that are consistent with the regulations that we have made, despite having extensively engaged with the Minister for Health, his department and wider members of the Executive on this issue for over a year now. But I put on record my thanks to the medical professionals who have ensured that women and girls have had some access to abortion services in Northern Ireland to date, and the organisations that have supported this work. And I would like to pay particular tribute to the late Professor Jim Dornan, a leader in his field and a passionate advocate for health issues such as cancer, but also women's reproductive rights. Looking ahead, our strong preference remains for the Minister of Health and his department to take responsibility for upholding these rights, to commission services and to deliver on what the law now clearly allows. And my Lords, let me make an important point. As abortion remains a devolved issue, the Assembly is able to legislate or indeed amend the regulations should they so wish, but only if they can agree a way forward that is convention compliant. But the Secretary of State has an ongoing statutory obligation with respect to ensuring that the CEDAW recommendations are implemented in Northern Ireland. It remains our preference that the Department of Health move forward with full commissioning of abortion services in line with the regulations, and that is why we are giving them every opportunity to act on this matter. I look forward to the debate, and I will seek to address as many questions as I can in my closing remarks. But, my Lords, I do hope that these regulations will be supported today, and I beg to move.
The question is that this motion be agreed to. Amendment, Baroness O'Lowan.
My Lords, I beg leave to move that the amendment standing in my name on the order paper. I give notice that I do intend to press my motion to a vote. These regulations give the Secretary of State for Northern Ireland a power to direct a Northern Ireland Minister, Department, Health and Social Care Board and the Public Health Agency to take any action for the purpose of implementing the recommendations in paragraphs 85 and 86 of CEDAW. The powers confirmed in these regulations are therefore extremely wide. My Lord, Government has asserted that there has a duty to bring these regulations, but there is no time limit. This is work in progress for the Assembly, and there can be no justification for intervening in the work of the Northern Ireland Assembly on this sensitive issue, disregarding the devolution settlement. My Lords, the regulations will be implemented through directions from the Secretary of State. They say that a direction will look like a statutory instrument, but my Lords, we have procedures for statutory instruments. We have no procedures which will scrutinise what is done by the NIO. My Lords, I ask you to vote against these regulations because the Assembly is sitting. The matter is devolved to that legislature. The regulations raise complex legal and constitutional questions. They go beyond the abortion Northern Ireland No. 2 regulations. They undermine the devolution settlement, not only in respect of abortion policy, but also education. There's been no public consultation, and the regulations were laid just before Easter, preventing the House from considering them before they came into effect. Your Lordships will recall this started in July 2019, when a group of MPs, none of whom represented Northern Ireland, urged upon the other place a duty to give effect to these recommendations of CEDAW. There was no obligation on Parliament to give effect to them. All the Northern Ireland MPs voted against them. Their votes and the votes of the Northern Ireland Assembly were ignored. My Lords, the Government didn't question what was said in the other place, and they proceeded to make an unworkable House of Commons clause into Section 9 of the Executive Formation Act. My Lords, there were no international legal obligations, something which the Government has now recognised. My Lords, This is a matter which should be dealt with by the Assembly. Work has been ongoing. There is a very firm belief in Northern Ireland that every life matters, that both mother and baby matter. There is provision, such as that suggested in CDAW 85 and 86, for support for mothers and for those who make the choice, sometimes with great difficulty, for abortion. Undoubtedly, more resources are required. Registered medical professionals in Northern Ireland do now terminate pregnancies lawfully at no cost to the mother. Such terminations must, under the terms of the regulations passed here, be carried out in health and social care premises. My Lords, 1,345 abortions were carried out in the past reporting year. Abortion is available in Northern Ireland and safely. My Lords, Northern Ireland has a health service which was described pre-COVID as broken. Mid-COVID, in January 2021, almost 1 in 5 of our population were waiting for a first outpatient appointment. Half of them have been waiting for more than a year. In December and January 2020, just before COVID, the Royal College of Nurses called the first strike action in its 103-year history in Northern Ireland. My Lords, with great respect, it is for the political representatives of Northern Ireland to devise a way forward on the provision of health services and abortion services. My Lord, Northern Ireland is in a parlous state. Our Assembly is functioning. Our political situation is very fragile. Brexit brought civil unrest. The terrorists, ever present, have become more active. Last week, a bomb was left in a car into which a young police officer was about to put her 3-year-old daughter. You will have seen the rioting, which was switched on Good Friday and lasted over 2 weeks. 88 police officers injured, civilians injured, families threatened, property destroyed. My Lords, Northern Ireland has a devolved government. Most recently, the Secondary Legislation Committee said that these are politically and legally important issues, and they should have had more consideration. My Lords, our Assembly is faced with more significant problems than the rest of the UK because of our history, the instability of our current situation, and the impact of the EU NI protocol. We are in a different place from the rest of the UK. My Lords, there is no imperative to affirm these regulations today. If affirmed, they will further mark the Assembly in its attempts to do business cooperatively. I cannot stress too strongly the volatility.
Can I remind the noble lady, please, of the timing?
It is important that your Lordship's House respects the attempts which are being made in Northern Ireland to deliver effective devolved government. I ask you, my Lords, to vote for my motion and to reject this further attempt to undermine the Northern Ireland Assembly. Help us, have courage.
The original question was that the draft regulations laid before the House on the 23rd of March.
Now that is Lady
Baroness
Baroness O'Lone, who is seeking to put down an amendment which really highlights the role that this is a devolved issue for the Northern Ireland Assembly. And if this amendment will pass, this will mean that these regulations will fall.
Between 3 nations.
We'll now go over to Lord Morrow.
A relationship in which together we are more than the sum of our component parts. The Union has worked hitherto because Parliament has recognised that it cannot be used to impose a uniformity that undermines key distinctiveness of the component parts. Parliament could, at any point since 1707, have voted to impose an English legal system on Scotland, but it has not, because this would be to fatally disrespect Scotland and render the Union unsustainable. One of the Northern Ireland's distinctives pertains to its approach to the unborn, as the then Secretary of State said in 2018. I quote, "Abortion has been a devolved matter in Northern Ireland since it was created in 1921, and it would not be appropriate for Westminster to seek to impose its will or to be the arbiter of an issue that has long been developed to the people of Northern Ireland. In the last 50 years in particular, we have developed a distinctive approach which affirms the importance of both lives, the life of the mother and the life of the unborn. This This may not matter to people in other parts of the Union, but it matters very much to the people in Northern Ireland. We are proud of the report which demonstrated in 2017 that 100,000 people are alive in Northern Ireland today who would not be had we embraced the Abortion Act in 1967 with the other jurisdictions in GB. Moreover, after a complaint and 5-month investigation, the Advertising Standards Authority ruled that this was a reasonable claim. What makes the regulations before us today deeply problematic is that they rest on the regulation making power in Section 9, which was developed on the back of a vote that took place on the 9th of July 2019, in which 100% of the Northern Ireland MPs who took their seats in Northern Ireland voted no, and yet this radical Northern Ireland only law change was imposed on us by MPs, none of whom has a mandate to represent Northern Ireland. My Lords, the strength and reality of the Union is not confirmed by the ability of the sovereignty of Parliament to impose legislation that only pertains to a component unit of the Union against the wishes of its representatives. Rather, it is confirmed by the fact that even though Parliament could impose in these instances, it does not, and instead respects the different priorities of the different components of the Union in order that the Union can continue. The passage of Section 9 and these regulations has swept these normal conventions to one side. First, it was argued on the 9th of July 2019 that Parliament was duty bound to pass the amendment that became Section 9 because Northern Ireland was in violation of International Human Rights Convention obligations under CEDAW and the recommendations of the 2018 Committee report on Northern Ireland. In paragraph 7.7 of the explanatory memorandum accompanying the regulations before us today, however, the Government now confirms that paragraphs 85 and 86 of the CEDAW Committee report do not constitute, and I quote, legally binding international obligations. As such, they do not provide grounds for overruling devolution, or more fundamentally, the understandings that make it possible for our Union to exist as the relationship that it is between its four component parts. Second, it has been argued that quite apart from international legal obligations, the law change introduced by Section 9 was necessary because of domestic UK legal process through the Supreme Court judgment on abortion in Northern Ireland in 2018. This argument, however, is plainly absurd. The Supreme Court made no binding whatsoever on abortion law in Northern Ireland. It reviewed narrowly whether certain elements of the law in Northern Ireland were not human rights compliant, not whether there was a general right to abortion. The two areas where the Court considered there would be no non-compliance under Article 8 of the ECHR were abortions on the grounds of a fetal abnormality and in cases where a pregnancy was a result of sexual crime. The judgment was not binding, but had Stormont been sitting and the law been amended accordingly, it would have resulted in a tiny increase in the number of abortions, and Northern Ireland's life-affirming legal traditions of Northern Ireland would have largely continued. My Lords, in the context where the existence of life-affirming laws is a long-term distinctive Northern Ireland legal tradition backed by its representatives on the 9th of July 2019, and where there is no justification for this sweeping this aside, either on the basis of international obligations nor the rulings of the Supreme Court, one has to confront the harsh reality. The only reason why we are here today is that Parliament decided to take the risk of dispensing the Northern Ireland tradition because doing so was a greater priority to members of Parliament and the continuation of the Union.
I now call Lord Shinkwin.
My Lords, I beg to move the amendment standing in my name and to give notice that I intend to test the opinion of the House. My Lords, I am a severely disabled parliamentarian who believes I have as much right to exist as anyone else. These regulations may not apply to me directly, but they still threaten me because they challenge that right by devaluing my existence. The narrative of these regulations is that I should not really exist. Indeed, I would be better off dead. My noble friend the Minister cites CBR, but I wonder how that narrative does not perpetuate a negative stereotype against disabled people, which CBR expressly prohibits. My Lords, if we pass these regulations today, not only are we endorsing lethal disability discrimination right up to birth, but we are in practice saying to anyone who is born with a disability that they somehow escaped the net. Now, to his credit, the Prime Minister has committed to publishing in the near future the most ambitious and transformative disability plan in the generation. So it is somewhat odd that Her Majesty's government should nonetheless think it appropriate to publish regulations whose ambition is not to transform the lives of human beings with disabilities, but rather to ensure that they never see the light of day. I have to say, my Lords, there seems to be a slight disconnect in the government's messaging. Perhaps my noble friend the Minister could explain to the House, to me, and to Harry Cahoon from Belfast, whose mother, Grace, emailed me yesterday, how it makes sense for the government to tell human beings born disabled that we want to support you, but only if we haven't found and killed you first. My bones break easily. Harry, who's a happy 17-month-old baby, has an extra chromosome. Brittle bones and Down syndrome, respectively, are our medical conditions. We both, therefore, meet the criteria in regulations that we have a physical or mental impairment that deems us to be severely or seriously disabled. So under these regulations, we would qualify for death right up to birth. My Lords, that is ultimately what these regulations are about: death for disability. In other words, state-sanctioned, state-sponsored, lethal disability discrimination. It is tragic that despite the immense sacrifices of my grandparents' generation, who fought and died in the war, that the eugenicist poison that informed Adolf Hitler's Action T4 euthanasia program against disabled human beings is now informing government policy and being imposed on the people of Northern Ireland. My Lords, we have a choice. Do we effectively endorse lethal disability discrimination, or do we instead send a resounding message of affirmation to human beings born disabled and to their families that your Lordship's House upholds their dignity and their equality? I beg to move.
The next speaker is Baroness Barker.
My Lords, I preface my remarks today by making the observation that it is against the law throughout the whole of the United Kingdom to compel or coerce a woman to have an abortion against her will. And what we are talking about here today is about the legal provision of services which are locally accessible to women and girls who need them. It's part of an ongoing debate between those of us who believe that women and girls are capable and have the right to make informed choices about their reproductive health, informed by health practitioners who wish to guarantee their safety, and those who do not. And I have to say to the Noble Lord Shinkwin, there was much that I took exception to in his speech. Today I do not have time to address his issues, but I do hope that the House will return to some of the very serious allegations that he made in his statement. My Lords, when you listen to the arguments today, you will hear many deeply held views. But those are deeply held views not about the devolution settlement. They are about the members' opposition to abortion. Members who oppose reform from Westminster, not only in Northern Ireland law, but support restriction of abortion rights across Great Britain, and have worked to enable nurses
ultimately
and
what this is about. This is about enforcing
abortion
ideology of the people of Northern Ireland.
To stop essential
there's a lot of talking
about
rights and law, but ultimately this is about forcing abortion ideology on the Northern Ireland Assembly, and these new regulations will give incredible powers to the Secretary of State to direct any Northern Ireland minister and any individual who is working for the Northern Ireland Civil Service in directing them to enforce abortions and also provision and ideology that is set out in the United Nations Committee report. So what we have here, these regulations coming to Northern Ireland, is something that is much worse than what is even happening in England, Scotland and Wales. In England, Scotland and Wales, abortion is not decriminalised. We have abortions completely decriminalised in Northern Ireland. And now this is the next stage, which is enforcing an abortion ideology whereby one will not be allowed to speak negatively about abortion in the coming years under the terms of the wide-ranging sweeping powers that have been given to the Secretary of State. So we'll go back into the debate.
To access healthcare that they need. I wish to ask the Minister, when does he envisage, what timetable does he envisage for women to be able to access services across the whole for health and social care boards in Northern Ireland? And when will we see the services which have proved so effective in England through the introduction of telemedicine? My Lords, for decades, women and girls in Northern Ireland have been weighed down by the politics of the past. Today is another opportunity for this House to give them hope for the future.
I now call Lord Dodds of Duncairn.
My Lords, at the very heart of this debate
Dodds
is, as noble lords have said, the women and unborn children and their families who are affected by this issue, and that is what we must always have at the forefront of our consideration. And I have to say I found what the noble Lord Shinkwin said very powerful and moving. As the father of a child born with severe disability myself, I understand entirely what he says, and having spoken and been very friendly with many, many families with children with disabilities, how richly rewarding they have found their family lives, and how powerful they speak to the value of every life, every life. And I think that is what must always be central when we discuss all the issues about constitutionality and about devolution settlements and Sewell conventions and parliamentary rights and so on. What we, on this side of the argument, simply ask for is that all lives matter, and consultation after consultation in Northern Ireland, and this is a devolved matter, has shown that the people of Northern Ireland have responded by saying that they value both lives and that they do not want the sweeping laws that have been introduced in Northern Ireland applied to them, certainly when no one has voted for that. And the fact of the matter is that we now have the most liberal abortion laws anywhere in the United Kingdom, and even if you believe in abortion, then you cannot say that that is a correct and proper process on which to proceed. for Northern Ireland. The fact of the matter is, my lords, that the Northern Ireland Assembly voted to reject these regulations on the 2nd of June 2020. So this isn't some theoretical matter which the Assembly hasn't considered. The Assembly did consider these matters, and because of the sweeping nature of the laws, rejected the regulations. The Secretary of State for Northern Ireland said at that time, and he's quoted in the BBC, as saying that he was committed to the regulations nevertheless because they must comply with a UN convention. But as has been pointed out, there are no such convention obligations. Paragraph 7.7 of the explanatory memorandum says that paragraphs 85 and 86 of the CBR report, on which the legislation was based, we were told was the justification, are not binding and do not constitute international obligations. So we need to be very clear when we come to vote exactly what we're voting on and keep those unborn children, all of them, in mind.
I now call the Bishop of Carlisle.
My Lords, we are all aware of the sensitivities surrounding abortion, as the Noble Lord Viscount Younger has observed, and also of the wide range of deeply held views that it provokes. But whatever our own particular standpoint on abortion per se, and of course it is now, as we've been reminded, legal in Northern Ireland, it seems to me that there are two specific aspects of the regulations before us which must be of general concern. One has to do with devolution, as we've already been reminded. To quote from a recent statement issued by the Archbishop of Armagh, it's a matter of regret that the Secretary of State for Northern Ireland intends to seek powers from Parliament to give direction to the Department of Health in Northern Ireland around what is clearly a devolved matter. Many others, including 250 clergy from several denominations in Northern Ireland, have made a similar point about these regulations undermining the devolution of the Northern Ireland Assembly, now that it is functioning again. There is a strong and widespread sense of democratic deficit in this regard. And the other issue which demands urgent consideration is the recommendation in the CBR report, 85B3, that abortion should be legalised in cases of severe fetal impairment, that is, disability, including Down syndrome. My Lords, we've debated that before in your Lordship's House, and it has been raised already in this debate. Members of the Assembly have also already strongly indicated their support for a private member's bill which rejects the inclusion of abortion on the grounds of non-fatal disabilities. And the regulations now before us seem to disregard that entirely. Indeed, they'd replace one of the most conservative abortion regimes in the United Kingdom with one of the most liberal and discriminatory, which accords neither with the wishes of a majority of Assembly members nor with the views of a significant majority, 79%, of those who responded to a recent public consultation on this subject. My Lord, for these two reasons in particular, I cannot support the regulations as they currently stand. But in the event that they are approved, I note that the Secretary of State is not mandated to use draconian powers to ensure their full implementation, and I do hope that it might be possible in that instance for him to work closely with the devolved administration to bring about an outcome that is rather closer to their position on this contentious topic.
I now call Lord Mackay of Clashfern.
My Lords, this is an instrument dealing with abortion. It is put forward under the authority of Section 9 of the Executive Formation Act 2019. The introduction to that Act states that what it proposes is subject to the formation of the Executive. As your Lordships know, the Executive has now been operational for 15 months, and accordingly it appears to me that the Act on which the Government is relying is not operative at the present time. In any event, there are only 3 grounds under Section 26 of the Northern Ireland Act 1998, under which this Parliament can intervene in a devolved matter by a statutory instrument in Northern Ireland. International obligation, safeguarding defence or national security, and protecting public safety or public order. The only question and issue under this statutory instrument is international obligation, and the Northern Ireland Office has made clear in its submission to the Secondary Legislation Scrutiny Committee that there is no international obligation which requires this particular instrument, nor is this instrument enforceable except by the questionable process of judicial review. Accordingly, it is contrary to these provisions for this instrument to be enacted. It is further of considerable damage to the settlement in Northern Ireland for this instrument to be forced on the people of Northern Ireland without the agreement of the executive. It is obviously a matter of considerable dispute in Northern Ireland, and it surely is the objective of devolution to allow such matters to be decided in Northern Ireland itself. In addition to these difficulties, House of Lords Secondary Legislation Scrutiny Committee have said that they regard it as poor practice to bring new policy into effect when the House is not sitting, using a procedure which prevents discussion before the legislation takes effect. It is particularly inappropriate when that policy is likely to be controversial, and the House, it says, may wish to ask the Minister to explain the decision contrary to the Convention of allowing at least 21 days between laying an instrument and bringing it into effect, why these regulations came into effect 8 days after laying. I would like, therefore, to take up the suggestion of the committee that the House may wish to press the Minister for further justification why the Northern Ireland Office decided to bring these regulations into effect in breach of the 21-day convention and during the Easter recess. My main point, of course, is the first paragraph of what I've said, that these regulations are ultra vires of the Secretary of State in the present circumstances, and I find it impossible to support them.
That is Lord Mackay of Clashfern, who is one of the strongest Christian voices in the House of Lords, formerly the most senior legal officer.
My Lords, we're being asked to give our consent to the killing of the unborn child. Many abortionists claim that abortion is the premature expulsion of the human fetus, but in reality it is the ending of a human life. They try to make it sound as non-violent as possible, but that is not true. As a pastor, I have met so many people, including young women, who find themselves in distressing circumstances, and with Christian compassion have sought to offer genuine help and practical support. But what of these regulations before us today? They go far beyond that which is legally required and are especially discriminatory against those diagnosed with disabilities. They are insensitive and offensive. We listen to those who piously proclaim that they would never do anything to undermine the Belfast Agreement or the devolution settlement. Yet the corrosive constitutional nature of this legislation is seriously damaging to devolution and is like throwing a hand grenade into the fragile structures of devolution. This is an unreasonable exercise of emergency constitutional powers when a devolved government is functioning. Can anyone imagine Westminster interfering in issues fully devolved to the Scottish Parliament? The answer is no. But the government, through this legislation, have crawled over the mangled bodies of little children to appease Sinn Féin demands before that party would allow devolution to be restored. My Lords, life in our nation has been devalued, and what is being proposed goes against everything God's Word teaches concerning the preciousness of life. Sadly, I believe part of the blame must lie at the feet of silent people who know better but never raise their voices to speak the truth in love. For years, the very thought of what happens in abortion outraged the community, but powerful lobby forces have been at work and through the media have sought to condition and harass people into acceptance. I fear that if we accept the taking of life in the dawn of its existence, we will soon be pressurised to take human life in the twilight of its existence as well. My Lords, I will not be silent, for my conscience is bound by the Word of God. Does no one care that children with a diagnosis of Down syndrome, etc., are to be torn from a mother's womb, although their lives are fully viable and valuable? Of course, the doors will not be opened for the public to see the tearful reality and truth about the various methods of the death of these children. Out of sight, out of mind. In a democracy, the major decisions is tested by the ballot box. But this legislation is being forced upon the people of Northern Ireland without mandate to do so. They are deliberately acting in defiance of the will of the elected representatives of the people of Northern Ireland. Over these past years, we have spent billions to save life, and yet in this 1.5-hour debate, we have been asked to sanction the killing of the unborn child. Indeed, many have been complaining throughout lockdown about what we do not have or where we cannot enjoy and where we cannot go. As we vote today, I ask you to hear the voices of thousands of innocent little children who have never had the opportunity to live outside the womb and before God stop another unnecessary death. I wholeheartedly support the amendments before the House, and I unreservedly reject the Government's motion.
I now call Lord Hope of Craighead.
My Lords, this is an emotional issue, but I wish to express my own concern about the constitutional implications of these regulations. To go back to the beginning, the legislation that introduced devolution to Northern Ireland followed a similar, although not identical, pattern to that adopted by the Scotland Act 1998. One of the issues that was much debated in the discussion about Scotland was what to do about abortion. In the end, it was decided that this should be a reserved matter, as it now is in Wales since 2006. The decision for Northern Ireland, on the other hand, was that it should be a transferred matter, and so within the legislative competence of the Northern Ireland Assembly rather than that of the UK Parliament at Westminster. My Lords, that was no accident. The Northern Ireland Act was the culmination of multi-party talks and the Belfast Agreement of 10th April 1998. Those who are legislating here were content, without question, to accept the result of these talks. I cannot help thinking that if the government was still respecting that result, as I believe it should, we would not be here today. Lords, the only reason why we're faced with this regulation is because of the duty placed on the Secretary of State by Section 9 of the Northern Ireland Executive Formation Act 2019. As we know, that act was passed while the devolution institutions in Northern Ireland were in suspense. Now, as the noble and knowing Lord Mackay of Clashfern has so correctly pointed out, the long title of that act states that one of its purposes was to impose duties on the Secretary of State, and I quote, to make regulations changing the law of Northern Ireland on certain matters subject to the formation of an executive. I agree with the construction that Lord Mackay puts upon those words. Northern Ireland now has a functioning executive, and the Assembly is now once again able to take these matters into its own hand and reform abortion law according to its own wishes. Indeed, it has spoken, as the noble Lord Doves has told us. So we're not in the situation that the qualification in the long title contemplates. I agree with the conclusion that Lord Mackay has drawn, and I suggest that we ought to have a careful regard to it when considering the noble Lady Baroness O'Loan's amendment. Lords, the Constitution Committee, of which I'm a member, has raised a question as to the prospect and desirability of different laws on abortion operating in Northern Ireland. This is a very confusing matter and disturbing matter because we're moving into very deep waters. I would be grateful if the Minister would respond as fully as he can to the question that the Constitution Committee has raised. One of the remarkable things about the Northern Ireland settlement is a unique provision in the devolution legislation which enables the Assembly to modify any provision under an act of the United Kingdom Parliament or made under such act as is part of the Northern Ireland. But it can only do this if it was within its legislative competence, having regard to other rights, including the Convention rights. So it's a complicated matter, and I'd be grateful for the Minister's further observations on that awkward situation.
Baroness Ritchie of Downpatrick.
My Lords, I am thankful for the opportunity to speak on this unprecedented move to provide the Secretary of State for Northern Ireland with such expansive powers. I share the concerns of many across the House and would like to concentrate on this particular issue in this debate. For me, who is pro-life, the debate is not about the rights or wrongs of abortion, but it goes to the heart of the devolved settlement, as already articulated by the noble and learned Lord Hope of Craighead. Under the devolution settlement, it is up to the Assembly to legislate exclusively in a wide range of matters, including health, women's health, including abortion. In this particular instance, I agree with the motions in front of the House, but I disagree with the regulations. If this proposed intervention, my lords, by the Secretary of State for Northern Ireland is allowed as required through the approval of these regulations, then a dangerous precedent is set, whereby the UK government can legislate directly on devolved matters whenever it likes. And I take note that the noble Lord the Minister said that this power was exclusively for the issue of abortion. But I would say, take note. I would also point out that allowing the Secretary of State for Northern Ireland such expansive powers as set out in these regulations is not only unprecedented, but also sets a dangerous precedent for the treatment of devolved powers in the UK, undermines the powers of our Assembly, and would be in contempt of the Good Friday Agreement. And it is worth noting that the Assembly was restored in January of last year. I am one that believes firmly in devolution, and I'm opposed to the principle of this legislation without prejudice to my own personal pro-life views on abortion. In 2019, Parliament during its last months voted to impose on Northern Ireland the extreme abortion recommendations of the United Nations CEDAW Committee. This is a UN convention to which the British government has signed up. However, CEDAW does not have any direct legal effect in Britain or Northern Ireland, I've been told. It can report and recommend actions, but they're simply recommendations with no binding international human rights obligations. Moreover, it is not clear how these powers conferred by the 2021 regulations are admissible under the devolved settlement enacted by the 1998 Northern Ireland Act, and it would appear that this is a constitutional overreach on such a devolved matter. I would ask the noble Lord the Minister to think carefully about this particular issue and withdraw these regulations. Thank you.
The next speaker is Baroness Eaton.
My Lords, as a Conservative and Unionist, I am acutely aware that the maintenance of our union does not depend on the imposition of uniformity. If our union is to survive, we must respect the key distinctives between the different parts of the union. Northern Ireland's long tradition of life-affirming laws may not be to everyone's liking, but we must acknowledge that they exist, not because of a stunted view of human rights, but because of a wider vision in which the rights of both the mother and the unborn have to be taken into account. I'm deeply concerned that rather than respecting the traditions of Northern Ireland, some representatives of other parts of the Union have actively sought to disinherit Northern Ireland from her traditions. We simply can't do that if we want our union to survive. The vote that started this process off in another place on the 9th of July 2019 resulted in all Northern Ireland MPs who took their seats in Westminster voting no. And yet this unwanted legislation was imposed on the province by MPs from other parts of the Union. I cannot think of any example of this kind of case that ended well. There was the flooding of the valley in Wales and destruction of the village of Capelcelyn in the context of 35 out of Wales' 36 MPs voting no. That is a huge issue in Wales for many people more than 50 years later. Similarly, the imposition of the poll tax on Scotland a year early against the wishes of its elected representatives provides another case in point. Both have been the subject of public apologies, and sadly, both now inform the narrative of independence in Scotland and Wales. My Lords, it is no surprise that legislation resting on such a troubled foundation should be less than straightforward. The regulations before us today cannot be enforced, certainly in the normal way. As the government conceded to the Secondary Legislation Scrutiny Committee, The only way of trying to enforce them would be to judicially review the decision of an actor to whom they are directed to ignore them. Given this difficulty and the implications of the nature of the vote of 9th of July 2019 on which they rest, I would suggest that rather than continuing with these regulations, the government gives Parliament the option to consider recognising the restoration of Stormont and repealing Section 9. In making this point, I would say to advocates of abortion liberalisation, what are you scared of? It is patently obvious to anyone who knows anything about the Northern Ireland Assembly that it is not going to move back to a pre-October 2019 position. Indeed, it is interesting that only legislative steps the restored Assembly has taken.
Can I please ask the noble lady to finish, please?
Yes, I am finishing. To consider a bill to prohibit abortions on the basis of non-fatal disability up until birth, a measure that would only prevent perhaps one abortion a year. I will certainly support the motion in the name of Baroness O'Loughlin.
The next speaker is Baroness Ho.
My Lords, the government says it has no choice and must bring these regulations because of the obligations placed on it by the Secretary of State through Section 9 of the Executive Formation Act. Well, I think we know now, having heard from many speeches and listened and read, that this is just not credible. And particularly, I think the noble Lord Mackay of Clashfetton has pointed this out so clearly. Firstly, Section 9 was brought in on the context of a piece of legislation, the purpose of which was to help restore the executive, alongside abortion remaining a key part of the devolution settlement. The executive has now been restored for 16 months, and abortion still remains in the devolution settlement. And secondly, the decision to introduce Section 9 was the decision of the last Parliament, and no Parliament can bind its successor, and every Parliament must have the right to respond to changing circumstances. That vote in 2019 on which Section 9 rests saw 100% of Northern Ireland elected MPs opposing Section 9, but of course it was imposed by the rest of the MPs, none of whom represented Northern Ireland. Surely Her Majesty's Government has learnt from the lessons of the past of trying to impose legislation on other parts of the United Kingdom. You know, as has already been mentioned, the poll tax, a brilliant example, a terrible mistake by a Conservative government and subsequently apologised for by David Cameron in 2006. And I would have hoped that riding roughshod over devolved governments would have been a thing of the past. And yes, it does seem to be a thing of the past for Wales and for Scotland. But somehow Northern Ireland is always, once again, treated differently. When it suits Her Majesty's Government, it is a devolved matter. I tried very hard to get, and other members, to get the word victim, the definition of a victim, to be the same in Northern Ireland as the rest of the United Kingdom. Oh no, I was told that's a devolved matter. And so many other examples of this. Just look at the treatment of veterans. We know now, of course, that the international obligations in which Section 9 was argued for is not binding. My Lords, these regulations are an assault on the constitutional dignity of Northern Ireland, and with the current instability in Northern Ireland as a result of another government diktat of the protocol, is going to cause even more instability and concern. I believe, my Lords, that your views on abortion is not about this. This is not about abortion today. This is about allowing a devolved government to make its own decisions on a devolved matter. There is a need for a debate in this in Northern Ireland, and maybe one way of getting an agreement on such a controversial issue will be a referendum. But what we do need to see, these regulations today, my Lords, are going to put a real, and I have to say it in a strange sort of way, but another nail in the coffin of devolution for Northern Ireland. We are being treated differently. People in Northern Ireland are getting fed up with being treated differently, and we can start today in this House of Lords by showing that we believe in devolution, and we believe in Northern Ireland peeping, the Northern Ireland Assembly having a right. Please vote for all these amendments, and can I congratulate Lord Shinkin on what I thought was an extremely moving and noble Lord speech, and I totally support him. Thank you.
I now call Lord Curry of Kirkhull.
My Lords, the regulations being proposed by the government are deeply troubling for the devolution settlement in Northern Ireland and the lives of the unborn. there is a danger that this regulation will further the damage done by the Northern Ireland Executive Formation Act. In that instance, changes were made without the executive's approval because there was no executive. However, there now is an executive in Stormont exercising its constitutional right to govern. Does the government no longer trust the institutions or leaders of Northern Ireland to govern? If the people and parties of Northern Ireland have a different view on abortion to this government, should they not be allowed to form their own laws and regulations? A motion was passed by the Stormont Assembly in June of last year, rejecting the changes which the government has made. At the very least, there is cross-party support for removing the right to abortion in cases of severe fetal impairments. This regulation takes no interest in the views of those representing the people of Northern Ireland. Instead, it assumes the Secretary of State is the person who should be responsible for these decisions. This principle potentially threatens the Union, and I'm sure voters in Scotland will be taking note. Furthermore, my Lords, I have concerns about the implication of this regulation on the lives and rights of the disabled. Paragraph 85 of the report upon which the regulation is based states that severe fetal impairment should be considered grounds for an abortion. However, it goes on to say that this should be done without perpetuating stereotypes towards persons with disabilities. This is a clear contradiction. If we are to say that we value the lives of the disabled, should we not also pass laws allowing for the abortion of disabled babies? We should not also pass laws allowing for the abortion of disabled babies. What does this say to those in our country and in Northern Ireland with a severe disability, as we've heard already? Does it not seem as though the government is saying that these lives are less valuable? Finally, in paragraph 86 of the report, it mentions protecting women from harassment by anti-abortion protesters, by investigating complaints and prosecuting and punishing perpetrators. What forms of anti-abortion protest does the government deem acceptable to take place in Northern Ireland? Will there still be space for peaceful exercise of free speech? Thank you.
I now call Lord Taylor of Warwick.
My Lords, a womb is not a tomb. In 1996, I presented the bill which created the UK's first DNA database. From the moment of conception, life begins with unique DNA which no other human soul in the world has. The word abortion in the dictionary means abandonment, death, destruction, expulsion, cancellation, rescission, revocation, and feticide. Cold, hard, final words which cannot be reversed. I oppose these regulations because abortion, first of all, is a devolved issue. The Northern Ireland Assembly has now been sitting for 16 months, so it's a serious violation of the devolution settlement for the government to impose itself further through the commissioning of abortion services, services which are already being provided. In the years since the abortion regulations were introduced, 1,345 lives have already been lost to abortion in Northern Ireland. There are now over 50 million abortions per year worldwide. That is more than one abortion per second. During the 90 minutes of this short debate, more than 5,400 babies worldwide will have been aborted. 79% of the consultation responses registered general opposition based on the historical and established position on abortion in Northern Ireland. Yet these regulations ignore this clear opposition. These latest regulations go beyond what is available in the rest of the United Kingdom, against the wishes of the Northern Irish people and the wishes of their politicians. For example, they permit gender-selective abortion, and there is no requirement that a doctor be involved. There is a clear breach of Article 10 of the UN Convention on the Rights of Persons with Disabilities, in that everyone has the right to life, whether able-bodied or disabled. My Lords, we start every day's session in both Houses of Parliament with prayers. So surely God's words in the Bible should not be ignored. Psalm 139, verses 13 and 16, emphasize how God views each and every life that he creates as ordained for a purpose and special, The verses read as follows: "For you created my inmost being. You knit me together in my mother's womb. Your eyes saw my unformed body. All the days ordained for me were written in your book." So we have a choice between man's regulations or God's words. My lords, it is a fact that everyone who is for abortion has already been born. Unborn babies do not have voices, but they do have rights. A womb is not a tomb.
I now call Baroness Fox of Buckley.
These regulations present me with a quandary, my lord. I look at the arrangements for abortion that these regulations allow for women in Northern Ireland with some envy. The unconditional access to terminations pre-12 weeks, a more liberal approach overall that effectively decriminalises abortion. This goes beyond the 1967 abortion law, and many of us who have argued over the decades for full reproductive rights for women would want such arrangements extended to the whole of the UK. Conversely, the position for women in Northern Ireland previously, when abortion was only legally permitted in very limited circumstances, was highly prescriptive and led many women to fear stigmatisation and criminalisation for decisions made about their own bodies, a fundamental tenet of women's freedom. The more recent problems created by non-functioning assembly, forcing women to have to travel for abortions or to see to term unwanted pregnancies, was intolerable. So I understand the justifiable argument for intervention while the power-sharing agreement was not functioning and women in Northern Ireland were effectively left without access to abortion services. But, and it's a big but, we now have a functioning Northern Irish Assembly, and while abortion is a devolved matter, something I prefer it wasn't, but it is, the imposition of these regulations by Westminster decree without consent, indeed in flagrant defiance of a rejection of these regulations by democratically elected Northern Irish politicians, is an obvious flaunting of democracy. Even where there are concerns about delays in commissioning services by the Assembly, why has the Secretary of State got such sweeping powers when we don't even know when they'll end? This is made worse by the sensitivity of the issue. Votes on abortion are rightly recognised as a matter of freedom of conscience. I do not agree with the concerns raised by the noble Lord Shinkin that post-24-week terminations represent any threat to the rights of the disabled, but I defend his right to put these arguments, and I acknowledge that this is a morally charged question. So a tone-deaf breach of an already strained devolution agreement on this issue does nothing to win the arguments for more liberal abortion arrangements in Northern Ireland or tackle the hard arguments. I would urge women's rights campaigners and citizens of Northern Ireland to put their energies into winning public support and a popular mandate for changes in the law in the importance of women's bodily autonomy. For choice campaigners to support a UK government deploying procedural chicanery that gives the Secretary of State unprecedented powers to expand abortion services seems to me to be cheating politically, counterproductive and anti-democratic. And by the way, 90 minutes to debate women's rights or Northern Irish devolution seems to be insulting to both.
I now call Lord Moylan.
My Lords, I have considerable sympathy with my noble friend on the front bench because his entire case, his entire legal case, and the whole legal basis for his proposal sort of collapsed within minutes of his sitting down after making his opening speech. In particular, as was pointed out by a number of noble lords, but particularly by the noble lords, learned lords, Lord Mackay of Clashfern and Lord Hope of Craighead, he needs an international obligation in order to give him the statutory power to override the devolution settlement. But his own department admits, and the explanatory memorandum admits, and our own Constitution Committee has indicated, there is no international obligation present in the CEDAW documents. But what really interests me about this whole measure is not simply the case, the assault it makes on devolution as an abstract concept, but the direct assault it represents on the Good Friday Agreement itself. Last year we discussed the Northern Ireland Protocol, a bad treaty in my view that has brought disruption to businesses and consumers in Northern Ireland, irrespective of communal affiliation. Jovian thunderbolts flew around this House at the thought that the government could modestly though unilaterally, alleviate that disruption to the practical benefit of the people there. The rule of law reigned supreme. But when we come to the Good Friday Agreement, Jupiter falls silent. But the Good Friday Agreement, we'd all agree, is a good treaty. It has ended terrorist violence and given Northern Ireland democratic self-government. Yet here we are, messing about with it on highly dubious grounds and with cavalier high-handedness. It cannot, as one noble lord said earlier, end well. My lords, earlier today at the dispatch box, my noble friend, my very same noble friend, Viscount Younger, spoke to your lordship's house of Her Majesty's government, and I think I have his words correctly, unwavering commitment to the Good Friday Agreement. That is not what we are seeing evidence of this afternoon. The weather has changed, with little explanation. It is yet possible, my lords, that the Secretary of State and the Northern Ireland Executive will reach an accommodation on this issue. But to achieve that with a gun pointing at the heart of the Good Friday Agreement is a price too high to pay, and I would urge my noble friend to withdraw these regulations and to think again.
The next speaker is Baroness Sooty.
My Lords, as this debate this afternoon has illustrated all too clearly, this is a subject that provokes extremely strong emotions. I welcome these regulations from the government, but regret that they are necessary. Contrary to many of the speeches we have heard this afternoon, there is in fact broad support in Northern Ireland and across party lines for the approach taken by the Northern Ireland Office in these regulations. Importantly, there is also a great deal of support for them from both the medical community and women's rights organisations, points made extremely powerfully this afternoon by my noble friend, Baroness Bolliker. It is also worth noting, my lords, that the regulations were adopted yesterday in the House of Commons by 431 votes to 89, a very substantial majority of 342 votes. I would like to pay tribute to the many dedicated healthcare professionals in Northern Ireland who have continued to support women and to provide reproductive health care in these most difficult of circumstances, made considerably more challenging by COVID-19. Speaking to friends and colleagues in Northern Ireland, there is a deep sense of dismay at some of the political games that are being played here. And there is much concern about some of the misinformation adding to the heat of this debate. The facts are that these regulations are only concerned with giving the Secretary of State for Northern Ireland powers to direct local health bodies and office holders to commission abortion services. And these regulations do not amend regulations and provisions for legal abortion care, which were supported overwhelmingly in Parliament last year. As the report published last week by the House of Lords Constitution Committee sets out clearly, we should also recall that these regulations stem from the legislation passed during the period when the Northern Ireland Executive was suspended and before it was restored in January 2020. The 2020 regulations sought to bring Northern Ireland in line with the rest of the United Kingdom in terms of reproductive rights and to ensure that the whole of the United Kingdom met its international requirements through CEDAW. It would, of course, have been hugely preferable for the Northern Ireland Executive to have fulfilled its responsibility directly, but it is now more than a year since the Executive was restored, and they have failed to do so. And this seems unlikely to change in the near future. And so, my lords, faced with stalemate in the Executive on these matters, these regulations before us today have become necessary. The debate this afternoon is really about ensuring the implementation of a law that has been in place for over a year now. It should not be about reopening or unpicking what should be a settled matter. My lords, debates about devolution and constitutional wrangling, as set out in several of the fatal motions before us today, must not be allowed to hide the facts about what is happening now in Northern Ireland as regards access to vital reproductive health care and the impact this is having on women's lives. Abortion in Northern Ireland is in a precarious position. 3 local health trusts have stopped providing abortion services, with the consequence that once again, women are being forced to travel to England for abortion services during a global pandemic, or are purchasing unsafe abortion pills online. Despite the new legal framework coming into effect over a year ago, services remain unfunded and without Commission support from the Northern Ireland Department of Health. It is surely unacceptable that reproductive rights vary across our United Kingdom. And for those colleagues who expressed concern about the potential impact of these regulations on the devolution settlements in Northern Ireland, I would like to reassure them that, as my colleague in Northern Ireland, Alliance MP Stephen Farry, has said, these are an exceptional set of circumstances and should not create a wider precedent. As the Northern Ireland Office Minister, Robin Walker, put it so powerfully during the debate in the House of Commons earlier this week, and the Minister has repeated here this afternoon, and I quote, "At the heart of this matter are the women and girls in Northern Ireland who have been and continue to be denied the same reproductive rights as women in the rest of the United Kingdom. I therefore urge noble lords to support these regulations and to reject all fatal motions."
I now call Baroness Smith of Basildon.
My Lords, it was just over 9 months ago that Noble Lord and I sat opposite each other at Dispatch Box, and the House debated the terms of the abortion provision in Northern Ireland as set out in the 2020 regulations. And it was exactly a year before that that I sat opposite the Noble Lord, the Lord Duncan, while the House engaged in what was then a very thoughtful and detailed debate on the Northern Ireland Executive Formation Act and the decriminalisation of abortion in line with the CEDAW recommendations we've heard about today. So, my Lords, this debate has been heard in your Lordship's House on a number of occasions, and we know there are deep, long-held, deeply held convictions across the House on both sides of the issue. Now, that's evident today from the amendments we see, but I would urge noble Lords not, in the language they use, to respect the views of other people too. Nobody has the moral high ground on this issue. And one of the reasons I feel so strongly about the provision of abortion rights in Northern Ireland, as the noble Lady Baroness Barker pointed out, it's not compulsory, it is a provision of services. Nobles may recall the reasons why the Republic of Ireland changed its law. And it was in 2012 where a young 31-year-old woman was denied an abortion following an incomplete miscarriage because the law wouldn't allow it, and she died as a result of being denied that abortion. Now, no noble lord in this House, I'm sure, supports that happening to any woman, but the right of life is for women as well, and that seems not to have been addressed in the debate we've had, and I'm sorry for the tone of some of the comments that have been made. So, my lords, it's now over 2 years, or getting towards 2 years, since the Northern Ireland Executive Formation Act was passed.
She's talking about a tragic case in the south where a woman lost her life. If you read the reports of that case, actually she lost her life due to sepsis and mismanagement of sepsis, and it was the hospital that were fully culpable for that. So that case was used in the south to change the law there. It's incorrectly again being used in the Lords today to justify the murder of preborn children.
Now, although the 2020
Ireland and the Republic of Ireland, when it had laws that did not allow abortion, had one of the lowest maternal death rates in the whole world. So the idea that you need abortion to save the lives of people is absolute nonsense.
The existing law is not being implemented, and that's the reason behind these very specific and very limited, as we've heard, regulations before us today. Today's order is supported by the Royal College of Obstetricians and Gynaecologists, the British Pregnancy Advisory Service, Amnesty International and Informing Choices Northern Ireland. And they report that early abortion services are currently beset with uncertainty They're being run by local health trusts without funding, which puts them at risk of temporary or permanent closure, and that multiple health trusts had to stop the provision of services for periods of time. Now, I've heard just this weekend that in the Western Health and Social Care Trust, services were being provided by a single doctor without support until, unsurprisingly, that was no longer viable. And on Friday, that trust suspended their early medical abortion services, effective immediately, and they're refusing all referrals. Now, today's order gives the Secretary of State the power to direct that necessary action be taken to provide
That's a very
safe
politically
abortion
calculated
services in
move by
Northern
the
Ireland,
Western Health
and the law
Trust,
requires it. And my Lords,
just
we support
very
it.
conveniently to
I do have
suspend
a
their
couple of questions for the Minister,
abortion
and one brief
service
comment
on the
if
Friday
time
before
allows.
this matter comes to
He said in his
Parliament
comments today that
in order to
Secretary of State doesn't
increase
intend to use
pressure
the
on
power to direct
MPs and
immediately,
members of
but
the
he
House
is
of Lords to
seeking further
force
action
through the
from Department of
commissioning.
Health,
And
for the summer
so
recess. If you can give any
rest
more
assured
information
that
on that, I
their
think it would be
Western Health Trust
helpful.
are ready and
Largely, I
prepared
think my
to
issue here
restart
is
the service
uncertainty,
as soon
that
as it is
continues.
practical to do so.
And secondly, I think it has to be recognised that abortion services aren't a standalone provision. They are a whole part of the wider landscape of reproductive sexual health services. Could the Minister provide further details on what supportive work is being done to provide counselling, access to contraception, and quality relationship and sex education alongside changes in healthcare provision? I think the two go hand in hand. And finally, my Lords, the Noble Lady Sutib said in her comments about
there we have
votes in the House of
education
Commons last night,
brought
these
up again.
regulations
The
were
previous
supported by
speaker suggested that these
431
laws
votes
only
to
give him the
89.
Secretary of State the power to
When we
direct
had the debate on the
the Department of Health. Of course,
regulations,
that's
I said
nonsense.
then, as an unelected House,
These laws give
our
him the
role
power
on
to direct
secondary
any
legislation is both
minister
limited
or
and
their
narrow.
government,
And I've said
including
something similar in the
education
Lord's
and
House on a number of
CEDAW,
occasions.
require
Now, at
him
times,
to implement an
we find that
extreme
frustrating. Nobody
sex
more than me, I
education
can say.
program in Northern
And it
Ireland,
remains frustrating.
where
But it also
abortion will be
remains
taught
my
as
view
normal
that
to our
that is our
children
role
in
of
their
secondary
schools as
legislation.
part of the sex
And I think it
education
would be
curriculum.
extraordinary
And it
if,
won't
having
matter
seen
if those
secondary
have
legislation
ethos,
passed
Christian
in the
ethos,
House of Commons and the other
the
place
Catholic
by
ethos,
431 to
they will be
89,
forced to do
this
that.
House would decide to take a different view and, in fact, pass fatal motions. So, as I've indicated, my Lords, I support the order and I oppose all three amendments.
I'd like to call the Minister, Viscount Younger of Lecky.
My Lords, I do thank, first of all speakers who have contributed to this debate on the regulations, a subject matter on which I fully recognise, as I said in my opening speech, is a sensitive and emotive issue. But can I start by just saying how much I appreciated the remarks from the Noble Baroness Lady Suttie. I thought that her speech was sensible, it was balanced, and in terms of where we are now, she said, and she used the expression with regret, and she's right, in terms of the position that we find ourselves in. And I'd also like to thank the Noble Baroness Lady Smith for her remarks. I was very grateful that she put extremely eloquently what we might both agree is the other side of the argument. And I was very moved by the short story that she gave about the very sad case of a particular girl. Can I just also directly answer one question she raised about the remarks that came from the Minister of State, Robin Walker, who said that the plan is that hopefully the Department of Health in Northern Ireland will take heed of what we are doing and move quickly. However, he's happy to have what he's called a pause before the summer recess. Now, what that means is that he wants to allow further movement from the Department of Health, is prepared to allow a little bit of leeway, and I hope that provides some clarity. But if
so
not,
basically, he's holding a gun to the head
question,
of the Department of Health.
On the extent and the quality of abortion services, an extremely good point. I may be able to address that later, but if not, again, I shall write to the Noble Lord.
Abortion services, but of the wider services provided on sexual health, on contraception and care.
Of course, that's an extremely good point, and I will pick up on that. But, however, my Lords, I recognise that several Noble Lords, and many today, have registered their strong opposition to what we are doing. But we are under a clear statutory duty, and it is important that women and girls in Northern Ireland are afforded equal rights to those living across the rest of the UK. Before turning to the substantive issues raised in today's debate, some Noble Lords have questioned the extent of our legal powers, and I would just like the House to note that the JCSI has not drawn the instrument to the attention of both houses for being ultra vires, but I will speak about constitutional matters later on, assuming that there is time. I also note, and I have read, the motions tabled by the Noble Lord Morrow, the Noble Baroness Lady O'Lone, and my noble friend Lord Shinkwin, and I hope that the answers that I give in relation to the issues raised will go a little way in explaining that these motions, in our view and my view, should not be supported. On the issues that my noble friend Lord Shinkwin raises about the potential for the framework set out in the March 2020 regulations to allow for discrimination against disability, I do, as he will know, respect my noble friend, and I am grateful to him for raising this important and sensitive issue once again. In response to his points, he should note that we are legally bound to implement the CEDAW recommendations, which include providing access to abortions in cases of severe fetal impairment, not only fatal fetal abnormalities. And it is our firm view that the regulations properly comply with the statutory duty under Section 9 of the NIEF Act, which includes implementing all of the recommendations in the CEDAW report.
So that's a really good
mirror the law in the rest of the UK,
shows
where
just how
abortions are
powerless
permitted
Stormont
in cases of
is.
severe fetal impairment,
Paul Gibbons' bill
fetal
sought
abnormality with
to
no time
outlaw
limit. The government would never act to discriminate on the basis of disability.
even though that would
The
only
regulations
stop
are consistent with the rights under the United
0.01%
Nations Convention
of
on the
abortions,
Rights of
the
Persons with
government are making
Disabilities.
clear that
Proper
any
provision of
such
information,
regulation of
clear medical
Stormont
advice,
will not be acceptable
counselling
under
and other
CEDAW,
supports are
and
all key
therefore will be
in
knocked
allowing
back
a woman or girl
in
to make an
courts
informed
or by the
decision on what are
Secretary of
often
State,
difficult
leaving,
situations. And I was very grateful for the remarks
leaving
made by the
Stormont
Noble
completely
Baroness
powerless
Lady
on
Barker,
this
who spoke eloquently and passionately about this aspect. This ensures access without barriers for victims of sexual crime, as well as other women seeking an abortion, supporting the rights of women and girls to make informed decisions about how they wish to proceed based on their health and wider circumstances within the health system, rather than looking to alternative, unsafe means. This provision was determined as the most appropriate way of meeting our statutory duty, and what CEDAW requires by ensuring that women, including victims of sexual crime, access services without undue delay, while avoiding anything that could lead to further trauma or act as a barrier to access. And I'd just like to pick up on a point raised by my noble friend Lord Shinkwin, and I will not be addressing his very strong views that he raised, and as he would expect me to say, I disagree very strongly with much of what he has said, I regret to have to say. But let me say this, that given the often late diagnosis and the timing of follow-up scans and tests, women will need to be given time to understand the nature and severity of the condition that they find themselves in. And it is only right that women have appropriate time to be able to make individual, informed decisions based on their own health and wider circumstances, including support, where they want to carry the pregnancy to term. And I think this was a point that was made by the Noble Baroness Lady Barker as well. It is crucial that the Department of Health act urgently to formally commission full services, consistent with the regulations that we made, so that these support measures can be properly delivered. As mentioned in my opening speech, I would remind Noble Lords that the Assembly can consider and debate issues related to abortion. Any amendments do have to be compliant, as I said in my opening speech, with the Convention rights. And the Secretary of State has an ongoing obligation to ensure ongoing consistency with the recommendations in the CEDAW report in Northern Ireland.
Again, confirmation there that the Assembly can debate regulation changes, however, they cannot change the regulations and make them more conservative from what has been given to us. The only changes that the Northern Ireland Assembly will be able to make at any point in the future is to make the abortion laws even worse than they are now.
Nor with the making of the initial regulations that came into force on the 31st of March 2020. The devolution settlement does not absolve us of our responsibility to uphold the rights of women and girls in this context. And although he may not agree with this, I think this goes a little way to answering the question raised by the noble and learned Lord Hope of Craighead. This is not about stepping on a devolved matter, as the noble Baroness Lady Hoey said. This is about ensuring compliance with the statutory duties that Parliament imposed on the Secretary of State for Northern Ireland in mid-2019. And can I say one thing, which was raised also by the Noble Baroness Lady Sutty, that I do not believe that the Noble Lord Morrow is correct when he says that all Northern Ireland MPs oppose this. And can I also just quote Stephen Parry, who said, "As an MP from Northern Ireland, I wish to stress my support for these regulations and the approach that is being adopted in this particular area by the Northern Ireland Office. There is a broad-based political support, and most importantly from the women's sector, for these regulations." And I'm echoing the words, as I say, of the Noble Baroness Lady Sutty. This should not be lost on the House, my lords. We are in a unique position on this issue, as Parliament, as I said earlier, placed the government under a very specific statutory duty with respect to access to abortion services in Northern Ireland. And that is why we have had to deliver the regulations and continue to have a role in this space. I have to re-emphasise the points to many who have spoken today, including my noble friend, Lady Eaton, and the noble Lord Taylor. While we made the regulations last March providing the framework for access to abortions and some service provision commenced, this has not discharged that statutory duty in full. We are not seeking to reopen the 2020 abortion regs, which were approved by a significant majority in this House, 332 to 99 votes last year. I just wanted to answer quickly some points raised by the Noble Baroness Lady O'Lone about the second Legislation Scrutiny Committee's report, which noted complex legal and constitutional issues. And I would agree that the issues raised are complex, but I would also agree with the House of Lords Select Committee on the Constitution, which was raised by the noble Lord Hope, that the UK Government and the Northern Ireland Executive should engage, it said, in a constructive manner. I recognise that some noble lords have concerns about the regulations providing unconditional access to abortions up to 12 weeks gestation. This provision was determined as the most appropriate way of meeting our statutory duty and what CEDAW requires by ensuring that women, including victims of sexual crime, access services without undue delay while avoiding anything that could lead to further trauma or act as a barrier to success. Based on current public data, 86% of the abortions accessed by residents of Northern Ireland in England under the Abortion Act 1967 in 2018 to 19 take place prior to 12 weeks gestation and would be covered by this limit. Just before I wind up, my lords, I just wanted to answer a point that was raised by my noble friend Lord Moylan and my noble friend Lord Mackay in terms of the international aspect of this obligation. It is true that the rules are domestic, so the duty to implement the CEDAW recommendations under this context is a matter of domestic law, of which the Secretary of State is under a statutory duty to deliver, not international law. But we recognise that Parliament has stepped in and imposed this duty on the Secretary of State for Northern Ireland on human rights grounds. So I think I addressed that directly. In conclusion, my lords, bearing in mind these further regulations are ultimately about ensuring the regulations made in March 2020 are implemented, and essentially they are about the rights of women and girls and being able to access medical treatment in distressing and difficult circumstances where they have a right to choose what is right for them, and we should act in a way, my lords, to support them in these cases, and that is why I commend the regulations to the House.
I would now like to call Baroness O'Lone.
My Lords, I have listened carefully to this debate. I'd like just to correct a couple of misapprehensions. Abortion services are available in Northern Ireland. They are funded. There were 1,345 funded abortions in Northern Ireland, and there have been no instances in which people have been refused abortion in a way that it was described by the Minister. More importantly, I think there are also support services available. We do need more resources. We always need more resources. My Lords, you have identified the important issues here as the protection of life and our constitutional settlement in Northern Ireland. My Lords, to revert to the Minister's last point, where Parliament has legislated, it can, using its sovereign powers, change the law. And this matter of the CEDAW regulations is not a matter of our international human rights obligations, is therefore devolved, and is therefore a matter which the Northern Ireland Assembly can change. My My Lords, I thank noble Lords for their thoughtful and considered contributions to the debate. I thank those who recognised the current situation and spoke to encourage the work of the Assembly. I thank the noble Lords, noble and learned Lord Mackay, and the noble and learned Lord Hope, and other noble Lords for their clear articulation of the nature of our constitutional devolution settlement, which is the product of the Good Friday Agreement, which is under threat. As we talk today, we have had people withdrawing their support, particularly in the Loyalist community, from the Good Friday Agreement.
Please move to the vote. Can the noble lady please move to the vote, as we're at the end of time?
I am. This is where I am. My Lords, in this feeble and volatile situation, I ask you to take courage. I wish to detest the opinion.
Order. I'm sorry. Could the noble lady please move to the division?
I said I wish to test the opinion of the House.
My Lords?
My Lords, I wish to test the opinion of the House.
Yes, I understand. The question is that the amendment in the name of Baroness alone be agreed to, as many as that opinion will say content. The contrary, not content. There appears to be a dispute which we shall resolve with a remote division. Clerk, please begin the procedure. Is open. Members are now invited to record their votes using the remote voting system. Members will have 10 minutes to record their votes and will make an announcement when the remote voting period is over. Clear the bar.
So the Lords are currently voting on Baroness O'Loan's amendment to today's debate. It says the amendment that she has says that this House declines to approve the regulations because they, 1, have been rejected by the Northern Ireland Assembly, 2, are legally flawed by being in breach of Section 6 of the Northern Ireland Act 1998, 3, do not prohibit abortion on the grounds of non-fatal disability, 4, perpetuates stereotypes towards persons with disabilities, including Down syndrome, and 5, do not prohibit abortion on the grounds of sex selection during the first 12 weeks of gestation, as is the case in Great Britain, and therefore perpetuate negative stereotypes and prejudices towards women. So there's some good stuff in her amendment. There's some stuff that we certainly would not agree with. It is true that the regulations, the abortion regulations, were rejected by the Northern Ireland Assembly last week, and the regulations being presented today are legally flawed because they're in breach of the Northern Ireland Act 1998, and that will form the basis of our judicial review once these regulations are approved. But the other 3 are really worth talking. The last one's a really interesting one. It says it doesn't prohibit abortion on the grounds of sex selection during the first 12 weeks of gestation, as is the case in Great Britain. So in Great Britain, it specifically says that you cannot have an abortion due to the sex of the baby. So this is one of the perverse things about this kind of argument. In the UK, it says you cannot have an abortion because the child is a girl, but you can have the abortion because the child is a baby. So, you can see on latest scans from around about 12 weeks, you can get an idea of the sex of the baby. So between 12 and 24 weeks in GB, if you don't want to have a baby girl, you are not allowed to walk into an abortion clinic and say, I do not want to have a baby girl, but you are allowed to walk in and say, I do not want to have a baby. Now, the problem with abortion is not the fact that it's not prohibited in Northern Ireland in cases of sex selection. The problem is that it is allowed in the case of the child simply being an unwanted child. So that's where I would disagree with Nuala Lone on that aspect of the amendment. Abortion isn't wrong because girls are more likely to be aborted than boys. Abortion is wrong because boys and girls are children who are created in the image of God, and the Bible specifically says, "Thou shalt not murder." It doesn't matter if the person is disabled or abled. It doesn't matter if they're a boy or girl. It doesn't matter what their religion is, what their color is. They are all created in the image of God, and therefore the murder of all of them is unjustified and unjustifiable. So the Lords are going to be voting for the next few minutes on the amendment, and then there are further amendments still to come that they will vote on. But I think, the whole way through that debate, you heard person after person stand up and say that this is unconstitutional. This wrecks devolution. There were a number who said it's it's like throwing. It was Lord McCrae said it's like throwing a hand grenade into what is already a very fragile situation in Northern Ireland. They simply don't care. So the Lords will approve these regulations. They will just go ahead and approve them anyway. They don't care. And I think it was Baroness Barker right at the start showed what this is all about. It's all about ideology. It's all about abortion ideology, and the the idea that they should have the right to murder their children whenever and wherever they want, and that is what this is all about. So we are currently arranging a meeting with our legal representatives over the course of the next day or so to speak to them, to challenge what's going to come out of the Lords and the Commons today. And this fight is very much not over, and that we will be taking it on further. Of course, there's news today that Arlene Foster is due to step down as the leadership of the DUP. And tomorrow night we will have our usual prayer meeting, and I think it's very important that we pray for the DUP. We pray for wisdom in terms of the appointment of the next leader of that party. We pray that they start to move back to their roots, and they reject pragmatism in the way that has been so disastrous for our country over the last few years. So we'll meet tomorrow night and we'll really pray into that situation. But
Mark, just on that point, just to let everybody know, we are organising a extra special time of prayer tomorrow afternoon at 4 o'clock. For those who are not able to join us in the evening, so we're having an extra time of prayer from 4 till 5 tomorrow afternoon on the Zoom channel, and also on the various social media platforms that we're on. Thank you for that, Mark. We have Nicole on, who's just joined us. Nicole, do you want to just give us some of your reflections on the debate and what you heard? Thanks.
From what I heard, thanks Wesley, the bit that really interested me was the fact that so many speakers spoke passionately about the interference with the devolution settlement and with the constitutional issue. And there was even a lady whose name I'm afraid I didn't catch, who was very passionately speaking in favour of abortion, but actually recognised that this should be a matter correctly decided in Northern Ireland. Lord Younger indicated, I thought, that he would return to the constitutional point. He is the government representative in the Lords. He didn't do so. But what was really striking for me was that what he seemed to be saying was that any time London wants to bypass devolution, it simply places itself under a statutory duty to do so. So in effect, the Secretary of State had no choice but to interfere in devolution because Parliament implemented Section 9 of the Executive Formation Act in 2019. Now, that's a curious argument, I have to say, because it would give the London government, Westminster, carte blanche to interfere in devolution in Northern Ireland, Scotland or Wales at any time that it saw fit. And I think it's one that certainly the legal team will want to be aware of the Secretary of State's arguments in those circumstances.
Of course, Nicole, it's also another lie. You know, they have they're trying to sell this as, well, the Secretary of State has no choice. Section 9 tells him he has to do this, so he has to step in. While at the same time, the government has an enormous majority in the House of Commons, and all they would simply need to do is put a motion to repeal Section 9, remove this from the Secretary of State, whip their Conservative MPs to vote for it, and it would pass. So this idea that he is bound by Section 9 and there's absolutely nothing he can do, he just has to do this because Section 9 tells him, is total nonsense, because they have the power to remove the law.
Agreed, Mark. I think that's exactly the point, that it is a nonsense argument. It's a dangerous one.
The remote voting period is now closed. I will announce the results in a wee moment.
It is a dangerous one if they are able to perpetuate it, because if it's not challenged and if it goes unchallenged, then effectively the government can pull this out of the bag every time it wants to interfere in another aspect of law within Northern Ireland. And I was very struck with just how informed the debate was, how we had it outlined for us that abortion is not a devolved matter in Scotland or Wales, but it is specifically devolved in Northern Ireland, which makes it even more acute that we're not claiming it to be a devolved matter. It is properly a recognised devolved matter within Northern Ireland. And therefore, the Secretary of State really has to sit up and take notice of what the 250 plus church leaders have said in the newsletter today, alongside their colleagues in the Free Presbyterian Church on Saturday, and also of other representations which are made to him regarding this, because the implications of what he is doing are incredibly serious from an abortion perspective, but they are also very serious from the devolved settlement perspective. And I appreciate this is somewhat complex, but I do think that the majority of those who spoke today have got that message and they understand it. So it will be interesting to see how this plays out.
Thank you, Nicole, and thank you, Mark. I certainly think one of the interesting points that Lord Morrow made in his speech was that abortion has been devolved in Northern Ireland since 1921.
Now announce the result.
And so this is a long-held historical position, but we'll just listen here to the amendment.
Not content, 418. The not contents have it. I therefore want to move on to the amendment in the name of Lord Morrow.
My Lords, before I move my amendment, could I just make a point of clarification? I think the Minister misunderstood what I said and he misquoted what I said, and I just want to clarify what I did say, and it was this. Back at a vote took place the 9th of July 2019 in which 100% of Northern Ireland MPs who take their seats in Northern Ireland voted no. And I'm sure the House will have noted today that no peers from Northern Ireland have voted in support of these regulations. I beg to move.
The question is that the amendment in the name of Lord Morrow be agreed to. As many as that opinion shall say content. The contrary not content? Not content. Once again, there is a dispute that we shall resolve with a remote voting. Clerks, begin the process.
As we are waiting then for the outcome of this particular vote on this amendment, I think it is worth noting that a comment was made that for such a serious issue, and for us, obviously, it's on the abortion issue, but as I was outlining just before we heard there from the House of Lords, it's also on the devolution settlement for Northern Ireland. I think we should really sit up and take notice of the fact that this was...
Members are invited to record their votes using the remote voting system. Members will have 10 minutes to record their votes. I will make an announcement when the remote voting period has ended. Clear the bar.
That this was afforded 90 minutes. And you will note that on occasions the speakers were hurried along to finish and make their points. And I think that that is perhaps something that we need to just take notice of, that these very serious, long-lasting matters which will impact on future lives are being debated within 90 minutes. And again, that's something which should be at the forefront of all of our minds.
Yeah, I think certainly one of my observations was it would have been lovely to hear more of our Northern Ireland peers speaking this afternoon. And I know certainly from some communications we had with other Northern Ireland peers, they weren't even aware that this vote was coming up until yesterday. And at that stage, it was too late to request the opportunity to speak. So every part of this process has been manipulated and cajoled in order to get it through and to prevent Northern Ireland having its voice. And that's abundantly clear for all who see what's going on.
The Lords are currently voting on Lord Morrow's amendment. So just as a reminder, it says this House declines to approve the regulations laid before the House on 23rd of March because rather than expressing the reality of union between the constituent parts of the United Kingdom, they place that union in jeopardy, depending as they do on the power in Section 9 of the Northern Ireland Executive Formation Act 2019, which was passed despite all of the members of Parliament representing seats in Northern Ireland who had taken their seats at Westminster voting against amending the Northern Ireland Executive Formation Bill on 9th of July to require the Secretary of State to make regulations to give effect to the recommendations of the report of this Committee on the Elimination of All Forms of Discrimination Against Women, published on 6th of March 2018. 2, abortion remains a devolved issue in the Northern Ireland Assembly and Executive have now been restored for more than a year. 3, rather than welcoming the restoration of devolution, the draft regulations undermine it to a greater extent than the abortion regulations 2020, as they address devolved competencies beyond abortion, including education and health. 4, the remit of everything in the Northern Ireland Executive Formation Act, except as defined in terms of moving towards the restoration of the executive, which has taken place. So rather than making new regulations, as if Stormont was still suspended and asking Parliament to pass them, Her Majesty's government should instead be asking Parliament to repeal Section 9. So a lot of the stuff in Lord Morrow's amendment is all purely constitutional. He is making a strong case that these regulations are anti-devolution, they're anti-democracy. They place devolution in a very, very complicated place. They also dabble within other competencies of the Assembly, including education. They are incredibly, incredibly dangerous. And instead of doing this, the government should be repealing Section 9. Now, Baroness O'Loan's amendment was massively voted down. I couldn't quite hear the numbers, but it was 400 and something to 89. So it shows you just how strong the pro-abortion lobby is, both in the Commons and in the Lords. And what we will see is this again on this amendment by Lord Morrow. You will see a similar kind of vote. And for me, it's even stronger on this one because they are voting. The Lords are specifically voting against the concept of devolution. They're voting against the idea that Northern Ireland will be able to set its own laws on a devolved issue. They're voting in favour of the government having the power to interfere in education, health, abortion, and other areas within Northern Ireland. And they're voting in favour of what is in effect the death of the simple idea of devolution. And they are voting to ignore the will of the people here. So this amendment in particular, I think, deals with the constitutional aspects, and it will be interesting to see how the vote goes. But I would expect it will go pretty similar to the last one. Another little point just to make, we had our open letter to MLAs was published today in the Belfast newsletter. There was one of the bishops in the House of Lords earlier, Bishop, let me see if I can find Bishop Carlisle, made reference to the letter during the debate. So the letter is from 250 ministers and pastors of a whole variety of denominations across Northern Ireland, asking for our MLAs to reject and resist the imposition of these regulations. And if the Secretary of State does act and does follow through and try to direct any minister or department for our pro-life MLAs to walk away and not return until the powers are returned to us here in Northern Ireland. It is an incredibly strong message, and if you've had an opportunity to pick up the newsletter, it's a double-page spread right in the centre of the paper. It is incredibly powerful, and we are so thankful for those 250 men and women who have made a stand for devolution, who have made a stand for democracy, made a stand for the unborn child, and ultimately have made a stand for their king. So we're really thankful to them. While the debate is going on today, we also have a delegation of ministers who are going to Stormont this afternoon, to Stormont House, to the offices of the Northern Ireland office, and they're going to be presenting a copy of the letter to the Northern Ireland office, addressed directly to the Secretary of State, with a copy of the letter and a covering letter, making it very clear that his intervention here will lead to the fall of the Northern Ireland executive and the death of devolution. So we're really thankful to those guys who are travelling up there today to hand the letter in.
My Lords, the remote voting period has come to an end. I will announce the results in a moment. My Lords, the results are now in. The question was that Lord Morrow's amendment be agreed to. There are voted content 63, not content 401. The not contents have it. We therefore move on to the amendment in the name of Lord Shinquin.
So I will keep my remarks very brief. I'd just like to thank all noble lords who spoke in support of genuine equality. I'm sure that that will be appreciated by disabled people and their families whose voices are so often drowned out on this issue. They know, as I do, that the idea that these regulations are not discriminatory is absurd. I beg to move.
The question is that the amendment in the name of Lord Shinquin be agreed to. As many as of that opinion shall say content. The contrary, not content. Not content. Once again, there is a dispute which we shall resolve by remote division. Clerks, please open up the remote division.
Also, please say a name.
The remote voting period is now open. Members are invited to record their votes using the remote voting system. Members will have 10 minutes to record those votes and will make an announcement when the remote voting period has come to a close. Clear the bar. My Lords, the remote voting period has closed. I will announce the results in a moment or two. My Lords, the results are in. The question was that Lord Shinquin's amendment be agreed to. There are voted content 70, not content 409. The not contents have it. That therefore brings us on to the question regarding the original motion. So the question is that the original motion be agreed to. As many of that opinion shall say content. The contrary not content. The contents have it. We're going to have a small break now to allow some people to leave the chamber and some others to come in, and we'll reconvene momentarily.
My Lords, we come now to consideration of Commons Reason and Amendment on the Financial Services Bill. These proceedings will follow guidance issued by the Procedure and Privileges Committee. When there are no counter-propositions, as for Motion A, the only speakers are those listed who may be in the chamber or remote. When there are counter-propositions, as for Motion B, any member in the chamber may speak, subject to usual seating arrangements in the capacity of the chamber. Any intending to do so should email the clerk or indicate when asked. Members not intending to speak on a group should make room for members who do intend to do so. All speakers will be called by the chair. Short questions of elucidation after the Minister's response are permitted but discouraged. A member wishing to ask such a question, including members in the chamber, must email the clerk. Leave should be given to withdraw motions. When putting the question, I will collect voices in the chamber only. When there is no counter-proposition, the Minister's motion may not be opposed. If a member taking part remotely wants their voice accounted for if the question is put, they must make this clear when speaking on the group. Lords following proceedings remotely but not speaking may submit their voice, content or not content, to the collection of the voices by emailing the clerk during the debate. Members cannot vote by email. The way to vote will be via the remote voting system. Consideration of Commons Reason and Amendment on the Financial Services, Earl Howe.
Okay, folks, that brings us to the end of our coverage from the House of Lords. The regulations have passed.
The question is that the Commons
That now
Reason and Amendment be
means
now considered.
tomorrow
As many as are of that
that
opinion will say
the regulations will go back to the House of Commons for royal assent, and that is the final stage of the parliamentary process. And then they're passed to the Queen for her signature, and that will make them legal. So from here on, then we're in a battle back at Stormont, and we're going to be outlining our next steps to oppose these bills and these regulations. So please do keep in touch, join with us. We're going to be back here tomorrow afternoon at 4 o'clock for our time, for our prayer time. So please do join us and encourage others to come in. Do make this a national time of prayer for our country. Pray for our political leaders. We can see it is bringing down Stormont, and with the announcement of the First Minister's resignation this afternoon. So much for God's people to be praying for, but we believe we're on the victory side. God wins. We must stand. Duty is ours. Results belong to God. So thank you so much for your support, and we're just going to stop the live stream now and